Good morning. This is a time set for oral argument. Our case number CV 180322, Williamsfield versus Stren. Counsel, good morning. Each side does have 20 minutes for oral argument. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Those who are present, I would ask that you make sure your cell phones are turned off so we can avoid any interruption by counsel's presentation and also avoid any embarrassment on your part. We have reviewed the brief, we've reviewed briefs, we've reviewed the record, we've conferenced the case. We'd encourage counsel to keep that in mind as you present your oral argument. And as you begin your argument, if you would, please tell us your name and the party that you represent. With that, Mr. Lorenz.
Good morning, Your Honors. May it please the Court, I'm Ryan Lorenz of the firm of Clark Hill, PLC, and I represent the appellant Cynthia Stren as executrix for the estate of Stephen Stren. Your Honor, the estate comes before this Court seeking reversal of a judgment in the amounts of $462,043 on one claim for recovery of a negative capital account, along with reversal of the other portion of the judgment for promissory notes in the principal sum of $97,320.40 plus interest on those claims. The issues we've raised are whether Judge Anderson abused her discretion in first sanctioning the estate at a pretrial conference, and secondly, by accepting and entering judgment on a stipulation reached during a continued trial proceeding on December 4th, 2017. We further contend that Judge Bailey, who succeeded to the division Judge Anderson oversaw, abused her discretion in failing to set aside the judgment under Rule 60. We think the Court's decision here should be guided by two overarching principles. On the one hand, due process, and on the other, the identification of any substantive or substantiation for the amounts set forth in the judgment. The concept of due process always leads one to wonder what process is due. Typically, that just involves notice and a hearing. The problem with the proceedings below is that the estate was never heard. There was no hearing. There was no default judgment hearing. There was no summary judgment. Rather, the Court entered judgment on a stipulation between one lawyer representing the estate who was clearly compromised and whose authority to enter into the stipulation was known by the Court to be lacking.
So, counsel, in your view, what should have happened regarding specifically, I mean, first of all, you wouldn't dispute that at least some type of sanctions were in order here, given the attorney's conduct or lack of conduct?
I concur. I think a trial judge faced with this situation can clearly see that there's a problem that probably is rooted further back. Yes, some sanction was appropriate. When you get to the level of striking an answer or referring the matter to a default judgment proceeding, the standard is higher for a trial judge. They have to have a good record. Moreover, in a lot of the discovery cases, such as Bird's International Corp., Zakroff, and Zimmerman v. Shackman, the suggestion is that the Court should undertake an evidentiary hearing to discover the root cause of the discovery problem. And the Rule 37B sanctions are given as the array or the tools in the toolbox, if you will, for imposition of Rule 16 sanctions. And so we look for guidance to those cases.
Counsel, that evidentiary hearing that you're talking about is sometimes referred to as a culprit hearing. Is that fair?
I don't know that. That culprit hearing was a term coined by, I believe, a Superior Court judge whose name I regretfully forget. But yes, a culprit hearing is specifically designed to determine between lawyer and client who's to blame and against whom the sanction should be imposed.
Or perhaps both, right? I mean, depending on what the
Yes.
evidence shows, but that, your point is that no such evidentiary hearing occurred in this case.
That's correct. And I think these cases that we've cited, and a lot of the discovery cases precede the so-called culprit hearing. But a culprit hearing certainly would have fleshed out the problems that John Flynn was having and had during the entire pendency of the case. And I can go into the gory details of that, but they were broadcast and brought to daylight down on the first floor of this building before Judge O'Neill. And it was very disturbing to hear what had gone on, which the estate and Mrs. Stren, who's present in the courtroom today, never even knew what was going on.
And do I recall correctly, at the pretrial hearing in late November, opposing counsel mentioned the concept of a culprit hearing at that time? Is that how you read that transcript?
During the colloquy, Mr. Porter did comment and referred the court to perhaps what I would consider the leading case on how to handle Rule 16 problems, which was the estate of Lewis case, a Division II case from 2012, and it cites a complete compendium of cases that should guide Superior Court judges in handling these problems. And I can get into the various cases discussed there, but having brought that case to Judge Anderson's attention, this sort of reminds me of an old quotation from the basketball coach John Wooden, who said, "Be quick, but don't hurry." And in the same proceeding, Judge Anderson basically dealt a death sentence to the trial presentation of the estate. She declared that there would be no witnesses, there would be no exhibits, all of the plaintiff's exhibits would be admitted, and there would be no jury instructions or contribution to the jury instructions or the voir dire process by the estate. That severely stacked the deck against the estate, who could have, at any even perfunctory trial, probably could have picked apart a lot of the partnership's claims, even without evidence. Because we can take a look at one example are the promissory notes. They're from 2002, 2005, 2006.
Counsel, before you get too deep into the promissory notes, because I want to hear about those, some of the issues, though, that you talk about went away when the jury trial went away, right? Voir dire, jury instructions, forms of verdict. And I don't know that I see your brief as challenging the jury trial going away. But help me out. I want to make sure I understand.
I believe that, in hindsight, Your Honor, in review of the entire record, I think that was Mr. Flynn's attempt to cover up the fact that the estate was going to be severely sanctioned. And without the ability to contribute to jury instructions or even ask questions during voir dire, he stipulated away the jury trial. And so he could say to his client, if he ever had communicated with her, this is going to be a bench trial and a more abbreviated proceeding. Not because he was sanctioned or that the estate was sanctioned, but because it just streamlined the presentation. But judge or jury, someone looking at the promissory notes would say, and this was a defense that was fairly presented in the answer to the complaint, was subject to a statute of limitations defense. Now, the estate would never have had to present any witnesses or evidence on that because the notes, the faces of the notes themselves are dispositive on that point. And yet, in the stipulation from December 4th, 2017, there was sort of a doomsday path laid out where if the estate didn't settle for everything that the partnership wanted, the partnership would get everything the partnership wanted. As far as stipulations go, Courts generally accept them, but we argue here that this stipulation reached after a recess in the proceedings was known by Judge Anderson to be entered into without client authority. Mr. Flynn.
And does that make it ineffective then, in the stipulation? Or what's the,
I think, Your Honor, I think that the proper course of action for Judge Anderson would be to pause and say, wait a second, you just told me that I asked you whether you reached your client and you said no. Then the lawyers lay out this detailed stipulation that has serious problems for the estate because it allows for entry of a judgment. And so I think she should have asked, you just told me you hadn't talked to your client, but you made a deal anyway. This deal with the devil resulted in an entry of judgment, and it was an impossible hurdle or path for the estate to actually reach a trial. If there had been a bench trial in January 2018, the outcome would have been strikingly different because at a minimum, the promissory notes would have been defeated. There should be no question about that. 2002, 2005, and 2006 promissory notes sued upon in 2014, 2016, there would have been no hope for the plaintiff to prevail on those claims. Moreover, as we discussed in the brief, the interest rate that found its way into the final judgment is completely at odds with ARS 44-1201. I want to talk briefly about the negative capital account claim, the larger part of the judgment. That claim suffered substantially from three independent and dispositive problems. On the one hand, fundamentally, a capital account or a negative capital account is not a debt. It's described and defined in the partnership agreement on pages 2 through 4. It's also discussed in Treasury regulations. And at bottom, a negative capital account is simply an accounting artifice whereby the partners define what their relative equities are. It's not a debt. Secondly, the estate sued Mr. Stren's estate on that claim, even though Mr. Stren was never the general partner. Instead, Mr. Stren's business entity, Williamsfield Management LLC, who we call WML, it was the general partner. So
was that raised in the answer somehow, or was that objection ever raised, as far as you're aware, in the Superior Court record?
I mean, I suppose in the answer one could argue that it's encompassed by the perfunctory defense of failure to state a claim upon which relief can be granted. But I would more accurately describe it procedurally as a misjoinder. WML could have filed a complaint to intervene and get joined to the action as a defendant, which would have secured a dismissal for the estate because the estate was the wrong party to sue, even if that claim had validity.
Were there, I'll call them corporate piercing claims, even though the LLC is not a corporate entity? Were those a portion of the complaint or not?
They were not. But to the extent the court would entertain the argument that WML should be disregarded, there was no evidence of that. Obviously, there's no evidence presented at all, but at first glance, there was no veil-piercing argument pled. Now, at trial, had there been one, if the evidence unfolded in a way that suggested a veil-piercing claim was appropriate, the court could have allowed amendment of the complaint even at trial. Most important point to remember here is that under ARS 29786, specifically subsection G, if an LLC is administratively dissolved and it cleans up its act and gets its filings in order with the ACC, what happens next is The reinstatement is retroactive to the date of administrative dissolution. Now, this too would have been a trial issue that wouldn't have required the procedural intervention of the company. Simply, the estate or the estate's counsel could have pointed out the glaring problem that under the documents of the partnership agreement and the pathway by which WML became general partner, there was no claim on the negative capital account against the estate. And so either way, whether WML intervened or whether cross-examination evidence was developed at trial, this claim would have gone away too. The last point on the negative capital account is that there was no consideration for it as a contract matter. In the documents under which this claim was made, WML was said to have succeed to all the powers, privileges, and obligations of the general partner. This is not a commentary on assumption of a negative capital account. It's not a financial transaction at all. Rather, it's simply a transitional document whereby a successor general partner was identified and signed an agreement. The obligations are not the financial obligations of a predecessor general partner. So to summarize, the partnership got a judgment in this case for over $450,000 on something that was not a debt against the wrong party and without consideration. Now, procedurally, obviously, we recognize that this court is going to impose a standard of review of abuse of discretion. We contend that under the guiding principles of the Lewis case, Judge Anderson went too far. Substantively, as presented in our motion to set aside from July 2018, we identified all of these defenses. And the fact that Judge Anderson never heard them, and the fact that she accepted a stipulation that bypassed all of them without knowing really what the issues were, was an abuse of Judge Bailey's discretion as well. I'd like to reserve a good chunk of my time, but I want to leave the court with this thought. John Flynn confessed to Judge O'Neill downstairs a few months ago that he had reached a point of consuming a half a bottle to a full bottle of scotch a day on days that he was not in court or in depositions. And since the briefing, I found a 1939 Nebraska Supreme Court case in which it's cited in an Arizona case, but it's called Seward v. Churn Ranch Co., in which the Sewards had hired a lawyer to defend them in a property dispute, and they lost 42 acres of their ranch. Sounds like a Nebraska case. The court said that the Sewards did not know judgment had been pronounced against them until the sheriff came to their ranch to dispossess them in April 1936. They again importuned their attorney to protect their rights and property, and he assured them he would rectify the mistake resulting in the judgment. They did not know he was a drunkard until they found him in a stupor at Gordon in July 1937. Now, we recognize the Panzino case works against us on this matter, but Your Honors, this has to be rectified somehow. Mrs. Stren and the estate lost over $700,000, and that the gatekeeping function of the court should have countenanced a different result. That's why we ask for reversal.
Thank you. Mr. Porter.
Thank you. Bob Porter here for plaintiff Williamsfield Higley Limited Partnership. May it please the court, The trial court here in no way abused her discretion. When one looks at the facts of the initial sanctions on November 20, the court struck any exhibits, allowed the Williamsfield exhibits, and did not permit witnesses. But by implication, the state of Stren could cross-examine and present law at trial. So in that context, it was not tantamount to a dismissal. That is the standard. And Marquez is the more recent case. And it's in our brief. It's a 2013 case. And in Marquez, they say the sanctions have to be tantamount to a dismissal to require a culprit hearing. And if they're not tantamount to a dismissal, no culprit hearing is required. And here there was no hearing, but Mr. Flynn freely confessed that he had not followed the trial court's pretrial order requirements that were laid out in August and had not done anything for the first pretrial on November 20. But the state of Stren was not deprived of due process because instead of a jury trial, they got a bench trial. And there's no loss of due process if you're trying the case to a court as opposed to a jury.
But it was a little more than that, wasn't it? I mean, it wasn't just that the jury trial or the right to have the facts determined by a jury went away. There was a cluster of other things that went away as a result of that hearing too.
Yes, there were. The state of Stren was allowed no exhibits. The plaintiff's exhibits were received, and the estate of Stren was not allowed any witnesses. But as I remarked earlier, the estate of Stren still could fully participate, fully cross-examine, and fully present the law to the court in such a trial.
And by fully, you mean cross-examine the other side's witnesses?
Correct.
That's it?
Correct, right. And that would be sufficient because the witnesses for the Williamsfield Higley were the current general partner who was presenting accountings that were made by Stephen Stren while he was alive that reflected his liability for the promissory notes and for the account, the negative capital account.
But even that limited non-jury proceeding where the other side could cross-examine witnesses went away later, right? Given inaction of the estate's counsel. It
was this, and this is really the heart and the core of what happened here, because come December 4, 2017, when this pretrial, when the trial had been scheduled, Mrs. Stren all of a sudden, 3 days before, let everybody know that she could not appear. And so and I don't remember if Mr. Flynn actually contacted Mrs. Stren first before the proceedings started or tried to do so during the proceedings. But during those proceedings, because we had this last-minute emergency motion to continue with all that going on, and with the record made before by Mr. Flynn, we worked out a stipulation, and it's been mischaracterized by the estate of Stren here. The stipulation was simply, look, it's December 4, we've got travel expenses for the general partner. If there's going to be a trial, he's going to have to travel again. So if you pay the travel expenses, you can have a trial as scheduled on January 29. Or you can settle it, one or the other. You can either by January 15.
Wasn't there reference to a judgment, though? I've read that transcript, and that you're not saying that the stipulation on the 4th of December is anything other than what is reflected in the transcript from that proceeding, correct?
And I submitted the complete court reporter transcript
Right.
for that proceeding. No, I'm not saying it's anything other than what's there in the transcript. Because the condition, rather I would say the sanction there, well, not a sanction, but to encourage to get things done one way or the other, if sanctions weren't paid by January 15, or if the case weren't settled by that time, then counsel, Mr. Flynn, agreed that the amounts that were specified were owed by the estate. That was the stipulation, and that was fully presented with the court reporter. The minute entry is confusing. There's no question that it is confusing. It leaves off in the main body of the minute entry and then goes back and finishes it off, so it's somewhat clear but still not clear. That was the minute entry, and the reason why I focus on that is that Mrs. Stren has said in sworn testimony that she saw that minute entry. And mind you, the minute entry was out there December 4. The deadlines were set in that January 15 with the bench trial of January 29. And Mrs. Stren said she saw that, and she objected to paying further travel expenses. But for whatever reason, no one from Gallagher and Kennedy, including Mr. Flynn, ever called me in between, ever did anything, and I repeatedly emailed Mr. Flynn.
And those emails are in the record,
right,
without question. Let me ask you to focus just for a minute back to the, I think it's November 20 hearing. At that point, you had asked that certain, I'll call them consequences because I don't want us to debate on whether they're sanctions or not, but certain consequences be imposed by the court, given the court's orders hadn't been complied with. The court then issued orders granting many of those requests. But along the line, you said, well, Judge, I'm not, at least as I read the transcript, to your credit, you say, Judge, I'm not sure if we need a hearing here to determine whether it's the client that ought to bear the brunt of these or the lawyer or some combination. Am I misreading what you said?
If that's in the transcript, no, you're not misreading it. It was news to me this morning, but if it's in the transcript, it's there. I mean, there's no question about it. If I said it, I said it. Yeah, the court reporter didn't make anything up.
Well, and I didn't think so. And it's not definitive. It's not, Judge, we got to set this hearing.
Right.
It's raising the issue, though.
Yeah.
Is there any point at that hearing where the court could divine, if the court was required to, whether sanctions, which appear to be appropriate, given court orders were sort of repeatedly or at least persistently not complied with, should be imposed upon the client or the lawyer or both?
Well, and I addressed that earlier. I think Marquez, the Rule 37 has evolved. Today's version is very clear. The trial courts now have complete discretion, even for a dismissal of a case, if orders are violated.
Complete discretion.
Well,
I mean,
well, because the Rule 37 that was in effect then said that for good cause you can allow late disclosed evidence, late disclosed witnesses. Now it says the court must find that there's been no prejudice from those late disclosed witnesses. So Marquez is very clear. The Marquez case is very clear. Unless the sanctions were tantamount to dismissal, and they were not. I mean, I asked for basically something close to dismissal. I asked that the answer be stricken, and I asked for some other relief. But those sanctions were not granted. But the sanctions that were granted were not tantamount to dismissal, so a culprit hearing was not required. Even though I mentioned one. So even though it came up, and apparently I alluded to it or said something about it, the trial court was not required to hold a hearing then a culprit hearing to determine if it was the attorney's fault or the client's fault.
Would you agree that it might have been the better practice here? I mean, you have an attorney who completely dropped the ball of many things here. I mean, and then that goes sort of to my next question, is like, how did he have authority to bind his client, Miss Stren, to that stipulation that would enter a $700,000 judgment against her? Where's the authority? I mean, so my question is twofold. I mean, so if the court had gone down this road even a bit of the culprit hearing and just trying to divine whether, this type of conduct merited, those types of sanctions. I understand that there are two different things, because then it leads to the stipulation later down the road. But why, first of all, why shouldn't the court have at least gone down the road a bit of taking some evidence on what the client was aware of?
Well, I think there's two questions there, and the first one is, really, shouldn't there have been a culprit hearing? And my answer is no, the case law didn't require
And I
it.
understand that.
Number one. And number two, when the stipulation that was presented on December 4 about paying the travel expenses or settling it, and if you don't do either one, you agree that these amounts are owed, that the authority of the attorney to do that has not been challenged. The challenge here is that the court should have abused her discretion because the court did not challenge that stipulation. And I think your question was it effective? I think it was effective. It was on the record. It was known to Mrs. Stren because she's on the record in her declaration saying she saw those minute entries. She saw them, and she tried to contact Gallagher and Kennedy and apparently was unable to reach them. But there's no...
She saw those minute entries, well, when did she see those? I mean,
She's a little murky about when, but the minute entry was issued December 4, and the next trial was January 29, with the January 15 date for paying the travel expenses. And Mrs. Stren's declaration said that you can imply that right after the trial date of December 4, she checked the publicly available minute entries to see what had happened, and then sought to contact Gallagher and Kennedy. Her declaration is in the record. It's IR 107, and it's Exhibit 13 to the filing then to set aside the judgment. And what she says here is, I did not agree to cover Bud Eisenberg's travel expenses.
Counsel, what's the date of that declaration?
It is July 29, 2018.
Right.
And then she says, in paragraph 18, I did not hear from either Mr. Flynn or Mr. Short or anyone else at G&K pertaining to the continuance of the trial and stipulation. I found out about later from a review of publicly available minute entries from the clerk of the Superior Court. I continued to press Mr. Short for an update because apparently the trial was reset for January 29, 2018. So Mrs. Stren, and it's natural. Here she says she couldn't travel for the December 4 trial date, and so she's looking to see what happened, reads the minute entry, and is following up on it. But my point is, she knew about it. She knew what had happened. She knew what the attorney had stipulated to. And the stipulation, no one from Gallagher and Kennedy ever said, I want to set aside that stipulation. It was never done, and it hasn't been done to this date.
I thought that the motion to set aside the judgment specifically challenged the authority of Mr. Flynn to enter that?
No, it did
Is it-
not. It really said it was an unfair sanction, that the court, what the estate of Stren claims is that the trial court abused her discretion in accepting the stipulation. That's the argument. The argument is not, well, here's a case that says the attorney can't do that, or here's this that says the attorney can't do that.
But isn't the basis for saying the trial court abused her discretion that he did not have the authority to enter the stipulation? Or am I misunderstanding that?
I'm not, the way I understand it, the stipulation was presented, and it was made then. There's no law that says that the trial court must look into whether the attorney has the authority to make that stipulation.
But what I understood counsel to be saying is not that the trial court had to go searching for it, but rather that the information already presented to her established that Mr. Flynn did not have the authority, i.e. that he had stated he had not spoken with his client that day, but nonetheless entered a stipulation that day that had not previously been discussed.
Right.
In other words, it was self-evident that he did not have the authority. That's the way I understand the argument, and that's the basis for the abuse of discretion. Is there something you're seeing that I'm not in that argument?
Well, yes, because there's no question that Mr. Flynn did not reach Mrs. Stren in the course of the proceedings once they started on December 4. And I can't remember. I've searched my mind and I can't remember. But I'm fair to 100%, but I'm fairly certain that Mr. Flynn reached Mrs. Stren before the proceedings started, because that's when the travel expense idea was first hatched. But
Is there anything in the record, though, because Mr. Flynn, after the break, at least I read the record from December 4, is saying he hadn't been able to reach his client during that break, and I think that's what you're referencing.
Right.
But is there any whisper in the record that this concept of a judgment, if a settlement couldn't been reached, was raised before this hearing? It seemed like things moved pretty quickly on December 4. There was a motion that the estate had filed that the division hadn't received, and that caused some angst
Right.
along the way,
Right.
understandably,
Right.
right? You're on the first day of trial, and you know, as a trial judge here, that trial's not going to happen. But I don't see anything indicating that the parties had this sort of settlement or judgment by the 15th of January concept discussed before they went on the record on the 4th of December.
Well, there was, because, and I...
Where would I find that in the record?
You wouldn't find it on the record, because court hadn't commenced yet, and Mr. Flynn, and, you know, I was there early with my people ready for trial, and so I knew then that Mrs. Stren was not coming, and so we launched into the discussion. And that's why in the transcript itself, Mr. Flynn first says, we've agreed to pay travel expenses. And then there's an interruption to see what else can be worked out. And then after that interruption, I come back with the full-blown stipulation about travel expenses or settlement, and neither then you agree to these amounts.
And there was a judgment referenced in there too, though, right?
Well, yes,
Yeah.
for certain.
And that was after the break.
That was after the break.
Can I ask one technical point on the judgment that you later submitted when, I guess it was radio silence from the 4th of December to the 15th or 18th of January? It has a 10% interest rate in there. Where does that come from?
From the statute, 1201, I think it is, off my memory.
And does that apply to the notes as well? Because didn't they have an express interest rate?
The interesting thing about the notes is they weren't present at this trial. The notes were late disclosed. They were disclosed after the judgment and after everything occurred. They were both late disclosed by Mrs. Stren, and then my client said, oh yes, I'd forgotten about those. They were buried in the archives. I did not have those for the trial. All I had were accountings that said, I owe all these amounts.
How would trial have looked without those notes? You sued on those, or your client sued on
Right.
those notes.
Well, I'll never know, we'll never know, because I was going with what I had, and they were accountings that Mr. Stren, while the general partner, prepared for the limited partnership that showed the amounts that were owed. Thank you very much.
Thank you, Mr. Porter. Mr. Lorenz, rebuttal.
Your Honors, I just learned something from Mr. Porter's argument, which is that the notes, which are of record in the court below, in the Rule 60 motion that we filed, were somewhere within the reach or within the custody of the plaintiff. That's very important because the plaintiff took a judgment on a rate of interest that the partnership should be imputed to know under 44-1201 was absolutely incorrect. What really happened here, Your Honors, is the partnership took advantage of a compromised lawyer. Mrs. Stren is thousands of miles away in Toronto. She has little or no contact with her lawyer. He enters into this doomsday stipulation that reaches a judgment for a staggering amount of money. It's based on a fiction. Wrong
Counsel, has
interest
she
rate.
challenged the authority of Mr. Flynn to enter into the stipulation? Was that challenged in the motion to set aside, or, I mean, not that the trial court abused its discretion, but is the underlying authority challenged, both in the Supreme Court and on appeal?
Yeah, I see my time is about to
Yeah.
expire. May I still
You may
answer?
continue.
Your Honor, it is challenged because both as a matter of abuse of discretion, because the judge should have recognized this was not authorized by the client on the spot during that recess. But secondly, as a matter of just basic agency principles, the lawyer is speaking without the client's authority. And the court's recognition of that missing link should have resulted in something different. That's, just dealing with the case hastily, that's hurrying. It's not being contemplative, that's not being deliberative, as we expect our trial judges to be. Your Honors, we request that the court reverse the lower court judgment and permit a new trial.
Thank you, counsel. We appreciate your briefing. We appreciate your presentation today. We will take the matter under advisement. We'll issue a written ruling in due course, and we'll take a recess while the courtroom set up for a next oral argument. Thank you.